So now let's begin with our second essential, that is free consent. Not only consent but free consent. So when two parties enter into a contract, there must be a free consent between those parties. Only in that case the contract will be considered to be as valid. Now what exactly is consent? Let's now discuss the definition that is given under section 13 of Indian Contract Act, which states that two or more persons are said to consent when they agree upon same thing in the same sense, which is also called in English law as consensus ad idem, that is meeting of the minds. Whatever I am saying, you also agree upon in the same thing in the same sense. Then it is said to be known as consent and consensus ad idem. Let me give you an illustration for a better understanding of this. Say, for example, you and I enter into a contract, and I give you an offer regarding the sale of my red color car for X amount, and you agreed for the purchase of my red color car. Now, in this example, you and I agree upon same thing in the same sense. But in another illustration, if I tell you that I give you an offer regarding the sale of my car for X amount. Now, I have two cars, black and the red one, but I have not specified which car. I just said that I want to sell my car for X amount. And you agreed, but you agreed for black color car because you thought that I am making an offer regarding my black color car, and you have given your consent for the purchase of my black color car. Now, in this example, I was basically giving you an offer for red color car. Basically, in my mind, I was thinking that I am giving you an offer for my red color car. But you thought that I am giving this offer for my black color car. Now, in this example, our minds didn't meet and we didn't agree upon same thing and in the same sense. And thereby, here, the consent is not free. Now, if there is no contract, if the parties have not agreed upon same thing in the same sense, that means if there is no free consent, the parties have their minds do not meet and they haven't agreed upon same thing in the same sense, then in that case there is no contract. And section 14 basically states certain factors upon which the consent is said to be not free. Contract Act requires not only consent but a free consent, and according to section 14, consent is said to be free when it is not caused by these factors, because when these factors are involved, the consent is considered to be as not free. What are these conditions? Coercion, undue influence, fraud, misrepresentation and mistake. Now let's discuss each one of them to understand better. Now, the first one is coercion. Coercion is defined under section 15 of Indian Contract Act and basically means to compel someone, to force someone to basically accept the terms and condition of the contract. Now, for example, if A and B enter into a contract and A has basically given an offer, but B gave that acceptance in fear of A, because A, say if A has basically placed a gunpoint on B, and due to that fear, B has given the acceptance. Now, this is an example of coercion. And when there is a coercion involved, in that case, the contract becomes voidable. Now, what are voidable contracts will be dealt in the later stage of the class. But now, understand that whenever coercion is involved, the contract becomes voidable. Now, another is undue influence. Now, there are certain relationships which tend to basically influence the decisions of the other part of the relationship. Now here, the relationships are such that one party is in a position to command the another, to basically give orders to the another. For example, parent-children relationship, doctors and the patient relationships. These are the relationships in which one party is at a higher authority than compared to the another, and thereby the higher authority person have a tendency to give a command to the lower authority person. And here, the consent that the lower authority person, that the other part of the relationship of the person will give, will be due to undue influence, and thereby such contracts are also voidable. Now next, we have fraud. Fraud means to deceive the another party. You are basically deceiving the another party and you are hiding something. Your intentions are not good, and thereby you are entering into a contract. Section 17 of Indian Contract Act defines fraud and basically means with an intention to deceive another party. Here you have intention to deceive the party. Now, next we have misrepresentation. Now, misrepresentation means the one of the parties have basically represented the facts or represented some other clauses or represented the other material things in an incorrect, false, inaccurate manner. Now, these situations falls under misrepresentation. That means one party has misrepresented the facts. Now here there is a distinction between fraud and misrepresentation, and that distinction is about intention, because here your intention was to deceive, but here your intention was not to deceive, but you have just represented it in a wrong manner. So the difference is behind the intention, and misrepresentation is innocent. That is, it is unintentional. Here the party who was basically misrepresented was innocent, but in fraud there was intention to deceive. Now we have our last category, which is mistake. Now mistake means that the parties who are entering into a contract, they have basically not agreed upon same thing in the same sense. We can say the terms and conditions are not clear between both the parties, and this is termed as mistakes. There was no meeting of the minds, there was no consensus at idem, and thereby this is known as mistake, and the consent here obtained is also not free. What happened when mistake is there? Then the terms and condition of the agreement is not clear. The parties do not understand the terms and condition in the same sense. Both parties understand consequences on the different terms, and thereby there is no consensus and idem, that means meeting of mind, and thus not understanding same thing in the same sense. Now this mistake can again be of two types. Okay, one is mistake of law, another is mistake of fact. Now mistake of wait a second, here there is an error. This will be mistake of law, and here it will be mistake of fact. So mistake of law. What is mistake of law? So ignorance of law is not excuse. So when you are giving an excuse that there was a mistake because you do not know that law, so that is not excusable, and this is known as ignoratio juris non excusat. Now I'm giving an example. You are rash driving. Right, you are rash driving and you do not have a driving license with you. And when police catches you and asks you for the driving license, and you said that basically I don't have driving license, I don't know that we need to carry driving license for driving. No, here you cannot plead this. You cannot say that you do not know that there is a law which states that. Ignorance of law is not excusable. Under contract, can't take defense that they do not know any law enforced India at that time. Now, mistake of fact is excusable, and this is known as ignoratio facit excusat. That implies ignorance of fact is excused. You can basically take this as a defense that basically you're not aware of this fact, and that is why you have mistaken, because you were not aware of this fact. Now, under Section 20 of Indian Contract Act, this term is explained, and contract is said to be void of both the parties are under in the mistake of fact. If both the parties are under mistake of fact, this is basically a good defense, and this is excusable, and the parties, and in that case, the contract will become void. But mistake of law is no defense. So I hope you understood what exactly free consent is, and when exactly the consent is not free, and what are exactly these terms: coercion, undue influence, fraud, misrepresentation, and mistake.